SDPB brings you closer to your government. With gavel-to-gavel coverage of the South Dakota legislature and in-depth reporting from Pierre. Good, useful, and full of wonder. SDPB. From early learners to lifelong students, SDPB inspires curiosity through trusted educational.
Okay. We'll call the Public Utility Commission meeting to order. It is 9:30 a.m. on July 14th, room 413 of the State Capitol Building. I am Chairman Nelson, and we have with me in the meeting room Commissioners Hanson and Fegan. Status on consumer utility inquiries. Deb Gregg.
Good morning. Thank you. The Commission received a total of 58 contacts since the last report was prepared for the June 30th, 2026 Commission meeting. 7 contacts related to telecommunication services, 30 contacts related to electric service, 2 contacts related to wireless service, 6 contacts related to natural gas, 3 contacts related to unwanted calls in the Do Not Call registry, 1 contact was related to wind energy, 1 contact we did refer to 1 call, and 8 contacts were related to issues that are not regulated by the PUC. 806 of the 822 contacts received in 2026 have been resolved.
Questions? If not, Deb, thank you.
Thanks.
Approval of the minutes from the commission meeting on June 18th and 24th.
Mr. Chairman, move to approve.
Discussion on the motion. Hearing none. All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. That brings us to our telecommunication dockets, and I think these first 3 we can take together. They are TC 26-003 in the matter of the request of Northern Valley Communications for certification regarding its use of Federal Universal Service Support, TC 26004, in the matter of James Valley Cooperative, and then TC 26-005, James Valley Wireless. Mr. Groff, thanks for being with us.
Good morning.
And would you or Mr. Kramer like to offer anything to begin?
Jim, are you on the
Mr.
line?
Chairman,
Yep, there you go. Sorry.
I am, Mr. Chairman. Thank you. Jim Kramer with Banskosh and Kramer. I represent Northern Valley Communications, James Valley Cooperative Telephone Company, and James Valley Wireless. And as you noted, the CEO of each of those companies, James Groff, is in the commission room with you. Today you have the application for each of these 3 companies. They were filed on May 13. We asked the Commission to issue a certification to the FCC and USAC in each of these dockets, and James and I are available to answer any questions.
Thank you. Staff?
Thank you, Chair Nelson. This is Joe Rezek with staff. Staff has reviewed the filing and will recommend the Commission provide a certification to the FCC and to USAC. Thanks.
Questions? Commissioner Fegan?
Thank you. On your TC 26-005, it looks like everything is confidentially filed, but in the past couple years, I've asked you about a program from Congress that you have been working on. Is that confidential? And it appears the items are done, but didn't know if you could talk about that or if that was totally confidential.
No, I can certainly comment on the fact we are completely done with that program. It's in the very end, kind of wrap up stages with paperwork and certifications and that sort of thing. We've received all of our reimbursements and everything. So.
Okay, thank you.
Additional questions? I've got one on TC 26004, James Valley Cooperative. Exhibit A, and we don't need to go into dollar figures because I know those are confidential, but Exhibit A lists your investment expenses. Does that include South Dakota Connect money, or is that outside of what you're reporting here?
Any investments or expenses that we've made, regardless of where the funding came from, would be in these numbers.
Okay. But we're not seeing any of the South Dakota Connect money that you received on this report. Is that? I'm not seeing it. Am I missing it?
It is not on here. I don't think it typically was on here, but there wasn't any. I mean, we've been completed on that for a couple of years now.
Okay.
I think, so.
Okay. Then that is all I've got. Any other questions? Hearing none, is there a motion?
Go ahead.
In TC 26-003, TC 26-004, and TC 26-005, I move that the Commission provide a certification to the Federal Communications Commission and to the Universal Service Administration Company regarding the use of Federal Universal Service support in each of the above dockets. Discussion on the motion. All the paperwork was in order. We understand what you're doing, and you're continuing to make progress. We appreciate that. Further discussion? Seeing none, all those in favor will vote aye. Those opposed, nay. Commissioner Hanson?
Aye.
Commissioner Fegan?
Fegan votes aye.
Nelson votes aye. Motion carries. Thanks for coming down. Appreciate it. Brings us to TC 26-010 in the matter of the consideration of a waiver of certain telecommunication annual reporting requirements. And this is a docket that was filed by Commission Counsel Ms. Edwards.
Thank you. The PUC receives certain information pursuant to administrative rules under Chapter 24 for IXCs and 32 for 2010-34. For IXCs and 2010-32 for local companies. That information was intended to be, in the rulemaking in 2025, the annual report information was intended to be ceased because we no longer compile a PUC annual report. However, there were a few items that were inadvertently left in, and we've received questions about that from several telecommunications companies this year that wanted to make sure they were in compliance. So although there's a pending rulemaking that the public can view now at RM 26-001 on the Commission's website, this waiver was to address those concerns that the companies had.
Thank you. And so just to be clear, the upcoming rulemaking will resolve this issue going forward.
Correct.
While there are no interveners in this, is there anybody that's here to comment on this? Okay, seeing none. Questions? Motions?
Mr. Chairman, in TC 26-010, I move that the Commission grant a waiver of ARSD 2010-3212 and 2010-2401 going forward unless otherwise ordered by the Commission.
Discussion on the motion. Is that second rule 2010-2404?
Oh, yes.
Okay.
Yes, thank you.
Discussion on the motion.
No discussion.
I'll simply say to Ms. Edwards, thank you for kind of catching this and figuring out a way to get us through until we can get the rule completed. So thank you for that. Additional discussion. Hearing none, all those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. That brings us to EL 25-028, in the matter of the application by Western Minnesota Municipal Power Agency and Missouri River Energy Services for a facility permit for an energy conversion facility and associated facilities, including an electric transmission line in Dual County. And the question is, shall the commission grant the applicant's motion to extend the decision deadline for 6 months, or how shall the commission proceed? And we will go to Missouri River Energy.
Thank you, Commissioner. James Moore on behalf of the applicants in this docket. The basis for the request is set forth in writing before the commission, but in summary, we're simply asking for more time to ascertain the best path forward based on a great amount of uncertainty and the complexities of finding an appropriate site for the proposed capacity power plant that's needed. As indicated in paragraph 12 of the motion, we need to build a plant somewhere. We need additional capacity. Capacity is not available in the market, and that means that we need a plant. We are looking for another site, as indicated in paragraph 9, but that's not a straightforward, easy process. It takes time. There are lots of considerations which are outlined in the motion. And assuming that we find a new site, that may or may not require a new application before the commission. So what we're simply asking for is time to continue the work necessary to find a path forward. We have a substantial amount invested in this project, and we have an agreement for an interconnection to MISO, to which Otter Tail Power is also a party because of the Astoria substation. And we want to make sure that we fully understand the implications of a new site with respect to that agreement, and we're continuing to work through that. I've read the concerns that have been submitted by comment to the docket. Most of those suggest that somehow this is disrespectful to the voters of Dual County who voted in the referendum. I don't think that's the case. We're trying to find a new site. We recognize that a new site is the most likely path forward here, but that does not necessarily require that the docket be closed and the application dismissed at that point. And so we respectfully request more time and an opportunity to do the work we need to do to figure out a path forward. And that's all I have, unless you have questions.
Thank you. Staff.
Thank you, Mr. Chair. This is Logan Shapar for staff. Staff has reviewed the motion filed by the applicants, and we do not object to the request. Thank you.
Questions? I do have several, maybe for Missouri River. Looking at your motion to extend the deadline, and I'm in paragraph 8. In paragraph 8, you say, because the moratorium is temporary, it is possible that under an amended zoning ordinance, rezoning approval and a conditional use permit for the proposed plant at the current location could be obtained. Because of the moratorium, no one is presently able to say that it is impossible. So I'm struggling to figure out how it would be possible. So step me through what you believe is feasible in order for that site to remain viable for you.
Sure, Commissioner. Again, this is James Moore. It would have to be rezoned, and there would have to be a conditional use permit. the only way that would happen is if current opposition to the project changed because of requirements that were included in an amended zoning ordinance that resolved concerns of the people who opposed the project at that location the first time. We don't know what the results of the studies that Dual County is undertaking pursuant to the moratorium are going to be. And if something changes in the zoning ordinance that affects the attitude of the people who opposed the project this time around in the future, then it might be possible to proceed at the current site. But we don't know that because we don't know what the zoning ordinance might look like in the future.
Thank you. I appreciate that. And obviously, Missouri River, since filing, has had numerous conversations with folks in Dual County. And so help me understand what kinds of changes could be proposed in a new zoning ordinance that would be acceptable and likely to swing, a third of the voters in Dual County from opposing to supporting.
I can't be specific about that, Commissioner. I can only speculate, and I think it's I don't think it's likely. As we said in the motion, the most likely path forward here is to find a new site.
I appreciate your walking through that. And so even with a new site, I'm struggling to understand how transitioning the existing application for a permit in some kind of heavily amended form to a new location would work. I mean, that just doesn't seem to make sense to me. Help me understand how you might see that working.
So it's a question that I asked to Commission Counsel and to staff. The question was simply, if we find a new site, do we necessarily have to proceed with a new docket? And the answer I got back was no. And again, Commissioner, I think it depends on where the site is, what the new transmission route looks like, where the interconnection point is, whether the same substation is involved. A lot of different factors that may or may not cause a significant change in the application. To the extent that the design of the plant remains the same, to the extent that the transmission line is of similar distance, to the extent that relatively few landowners are involved, my understanding from talking to Commission Counsel is that we would not necessarily have to file a new docket. If it turns out that it makes sense to file a new docket, then we would ask that this application be withdrawn, and we would file a new application and a new docket at that time. Because the answer to that question isn't clear at this point, we're simply asking for time to discern the path forward and to take appropriate steps in the future.
Thank you. I appreciate that discussion. I think technically the answer you got from Commission staff was correct. I just, given the realities there, I'm struggling to see how that could actually play out, even though it's technically accurate. But appreciate the discussion. Additional questions? Seeing none, motions. Well, Commissioner Fegan.
Mr. Chairman, in EL 25-028, I move that the Commission grant the applicant's motion to extend its decision deadline for 6 months.
Discussion on the motion.
So this gives Missouri River an opportunity to just look at what Dual County has said and see if there's any things they can change. I don't know. I'm not voting today that you can keep the same application or not. It all depends on many, many things. So that is not my vote today right now. It's mostly to say I I'm extending it for a time certain, which is February, I think, 7th, right? Or February 4th, I can't remember. Yeah, February 8th, I guess. So we'll have to look. I think the Commission Advisor did give you appropriate counsel. We just have to evaluate it. We never know until we see everything.
Additional discussion. Commissioner Hanson.
Question. So that is your motion to defer to a date certain, February 8th, as requested, as opposed to allowing us to have it open-ended?
Correct. I did say 6 months.
Okay, thank you. My only comment is that it appears that the applicant is doing exactly what the folks in Dual County wanted him to do, is look for a different location. So I support the motion.
Thank you. I'm going to probably oppose the motion. I will tell you, when I first read the filing, I thought, okay, let's give them 6 months. But as I really thought about it, and I think as you can tell from the questions I asked today, I am not at all convinced that 6 months is going to get them anything, at least in that area, and probably not in Dual County. The vote of the people was so resounding that I don't see a path forward in Dual County. Now, if they can figure something out and something that will, that people will be pleased with, great, but I just don't see it at this point. And so with great respect, I'm going to oppose the motion, but understand where you're going. Additional discussion.
Question. So are you in favor of having it open-ended?
No, just because I don't see a path forward.
All right.
Yeah. Additional discussion. Hearing none. All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes nay. Motion carries. That brings us to EL 26-003 in the matter of the application of Black Hills Power, doing business as Black Hills Energy, for authority to increase its rates for utility service in South Dakota. And the question that is left over from 2 weeks ago is, shall the commission grant Mr. McKee's motion to adopt a protective order? Now, we've had an intervening filing that maybe shakes this up a little bit, but we do have to resolve this motion. Mr. McKee is on the line, and so I'm going to let him speak first, and then we'll go to Black Hills and the large load folks and see where we end up. Mr. McKee.
Oh, thank you, Chairman. Actually, it's gotten a lot simpler than some may think. Black Hills Energy and I have come to a grand meeting of the minds. So much so that I have filed a motion to disengage myself from this proceeding and withdraw my petition to be an intervenor. And if you would give me a few moments, I have some closing statements that I can make and be done with it.
Actually, I think maybe we'll hold those statements, because we will have to take up your motion to withdraw as an intervener, and that'll probably happen 2 weeks from now. And so let's save those statements for that time.
Okay.
And with that, we will go to
get it done today.
With that, we'll go to Black Hills.
Thank you, Commissioner. This is Doug Law, Associate General Counsel. And as Mr. McKee indicated that, and from the last meeting that we had where this issue was before the commission, I think you had given us some direction to try to sit down and work with each other, which we did on at least a couple occasions, and then finally came to the conclusion that with Mr. McKee, that maybe the more expedient administrative way to go forward would be just to have him move from an active intervener to one of the general public. So we believe this is in the interest of everybody. And so as far as his motion for confidentiality, I think that would be rendered moot, and we would still ask that the commission deny it to the extent that it needs to be acted upon. And then with Mr. McKee's additional motion to withdraw from the case, then we would obviously be in support of that.
And we're not taking that up today since that's not noticed. Correct. So we will go to the large load, large customer folks.
Thank you, Commissioner. James Moore. We have we more or less have nothing at stake here if Mr. McKee is moving to withdraw and is no longer seeking entry of a protective order.
Thank you. Staff.
Thank you, Mr. Chair. This is Amanda Reese for staff. I guess just to fill in a bit, before Mr. McKee filed his motion to withdraw intervention, I think the parties had all come to a meeting of the minds that we needed to at least defer the motion. So I think at this point, the question is whether you defer it or flat out deny it and then take up the request to withdraw intervention at the next meeting, and I would leave it up to the commission. Staff has no particular preference.
Thank you. Questions? Motions?
Mr. Chairman, I'm glad to see that folks have a meeting of the minds. That was the intent of my motion to defer, and I will withdraw the motion that I placed on the agenda for today and eliminate that portion of the need for any discussion in future.
Thank you. In EL 26-003, I move that the commission deny Mr. McKee's motion to adopt the protective order. Discussion on the motion. We need to do this in order to take care of the motion that's on the floor. Yes, agree. I'm glad that there was good discussions over the last 2 weeks. I will also say, just kind of for the benefit of everybody, I've done some poking on the key question about confidential information and its use by interveners in AI and what types of appropriate protections there should be there. And I got to tell you, this is novel. Nobody else that I can find has dealt with this. And so if this had been resolved in that way, we might have been trend-setting in the country on this question. But I guess at this point we won't be. But it truly is a very, very novel question, and I was surprised that other commissions had not dealt with it already. Additional discussion.
When you say we may have been trend-setting, it might have not been a unanimous vote. It might have been a no on this side.
Further discussion on the motion. Hearing none. All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. That brings us to EL 26-012 in the matter of the joint request for approval of an electric service territory memorandum of understanding between the City of Vermillion and Clay Union Electric. And the question is, shall the commission approve the requested service territory exchange agreement between the City of Vermillion and Clay Union Electric? And we will go to City of Vermillion.
Thank you, Commissioner. Shane Grease, City of Vermillion. Just to give you guys a little background, so the city was approached by a developer that was looking to build some apartments. The lot that they were proposing that on was actually split with the service territory. About 2/3 of it was in the city's territory, with the remaining out in Clay Union Electric's territory. That developer wanted the entire development to be served by the same electrical provider. So the city and Clay Union worked together. We came up with an agreement to make that project move forward. The territory swap that's in front of you today is what both parties kind of came to an agreement with, and happy to answer any questions that the commission may have.
Thank you. Clay Union.
Good morning, Mr. Chairman. Steve Tilton, General Manager, Clay Union Electric. This matter was taken care of prior to me arriving at Clay Union Electric. It sounds like it's been fully vetted, and I have no opposition to this.
Thank you. Staff.
Thank you, Chair Nelson. This is Joe Rizek with staff. Staff has reviewed the filing and would recommend the commission approve the requested service territory exchange between Vermillion and Clay Union Electric. Thank you.
Questions? Motions?
Mr. Chairman, in EL...
Excuse me.
Go ahead, Commissioner Fegan.
Mr. Chairman, in EL 26-012, I move the commission approve the requested service territory exchange agreement between the City of Vermillion and Clay Union Electric.
Discussion on the motion.
Well, it looks like Chris Larson's work is still on the table for the commission, even if he is now at GOED. But thank you so much for working together and seeing efficiencies in our electric business. So thank you.
Additional discussion, and the only other thing I will state is The exact legal description of these boundaries proved to be a little bit tricky, and I appreciate everybody taking a second look at that, making some corrections so that there's absolutely no question going forward where the exact boundary is. So thank you all for that. Additional discussion. Hearing none. All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. That brings us to EL 26-014 in the matter of the application of Crown Ridge Energy Storage 1 LLC. And the question is, shall the commission grant party status to those who may have filed? So here's what we're going to do today. We're going to deal with the request from the Lindgrens, and we're going to deal with the request from Coddington Clark. There were some others that came in very recently that we are not going to deal with today. We will deal with those probably in 2 weeks, but we do have the three that are on tap for today. And so with that, Mr. and Mrs. Lindgren, if you'd like to say anything, why, this is your time. You got to come up here, punch the button, get online so the world can hear you.
We're basically at ground zero of this battery storage system. It is across the gravel road, across from our pasture and cropland, and there's cattle grazing there, and it's close to the aquifer and close to our well, and a half mile from our house, and we're already at 45 dBA at our house from the wind turbines, so I believe it's impossible to add anything more. And since we're not participators, they can't go to 50, so. And a lot of people in South Shore and the area are with us on this. That's about it. Tim?
Yes, I've
And if you just give us your name for the record.
Tim Lindgren. And I've resided on this property for 66 years now. And I don't really have any intentions of moving. And if we don't have to move, where are we going to move to? And I've been a lifetime member of Coddington Clark Electric. It's a company that my parents and grandparents have helped build, and I hope they're not working against us on this. Thank you.
Thank you, sir. And we'll go to Coddington Clark.
Hello, my name is John Knight. I'm a lawyer in Watertown. I represent Coddington Clark Electric Cooperative, and we've moved to intervene. The project is in the Coddington Clark Co-op service territory. We anticipate that we'll have a meter at the site. We want to make sure that in our agreement with Crown Ridge that there isn't anything happening at the PUC level, that there aren't any issues being presented or decisions being made without us being involved and having at least notice of that, and then opportunity to review that and compare that to the agreements that we're making with Crown Ridge. So we just think it's important that we're allowed to track what's going on and be present, and if something comes up, have an opportunity to express any concerns that we have.
Thank you. And we'll go to Crown Ridge.
Thank you, Commissioner James Moore, on behalf of the applicant. We do not object to these applications for intervention. Thank you.
And staff.
Thank you, Mr. Chair. Jenny first for staff. Staff would recommend the approval of Timothy and Linda Lindgren as they fall within 2 miles of the project. Staff would also recommend approval of Coddington Clark Electric Cooperative as they are directly interested in this docket due to it being located within their service area. Thank you.
Thank you. Questions? Motions? Commissioner Hanson.
We are on 2014.
Yep.
Mr. Chairman, I move that the commission grant party status to Timothy Lindgren and Linda M. Lindgren and to Coddington Clark Electric Cooperative.
Discussion on the motion.
Well, these folks have filed within the time limit that is required of them, and they certainly have every reason to expect to have, and they qualify for party status.
Thank you. Additional discussion. Yeah, I will just emphasize that, we look very carefully at what the statutory parameters are for who can and cannot be an intervener, and these three certainly meet that requirement. Additional discussion. Hearing none. All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. To the Lindgrens, thanks for coming over. Long drive, I know that, but you're in. Quickly.
The 2-mile thing, does it have to be within 2 miles?
That's not something that we can talk about at this point. That was simply a statement made. You're free to visit with her following this about that statement. With that, we'll go to EL 26-017 in the matter of Otter Tail Power Company's petition for approval of tariff revisions to its South Dakota rate book, section 101.05. And the question is, shall the commission approve the tariff revisions with an effective date of August 1st, 2026? Otter Tail.
Brandon Johnson, Otter Tail Power. Just looking to formalize an otherwise non-formal process with the application for customers to complete rather than email correspondence or handshakes.
Thank you. Staff.
Thank you, Mr. Chair. Jenny first for staff. Staff would request that this tariff revision is approved with the effective date of August 1st. Thank you.
Questions? Commissioner Fegan.
Thank you for Otter Tail. I was very surprised that you didn't have this type of process before. Do other utilities have this type of process and you just haven't went to a form like this, or you've done everything informally?
Commissioner, or Chairperson, I can't speak to other utilities. Most of what we do is very formal. This was one of those that were not.
Okay, thank you.
Additional questions? I've got just one. So give me, one or two examples of the types of things that this would be used to cover.
Primarily, it would be situations where there is a request on the customer to, we'll say, move a pole in their yard where our services are fine, use, and usable, and they would like it relocated to a different part of their property. Or if we have overhead line feeding a house or a business and they simply are requesting to move it to underground. So again, no added value to rate base, just a customer request for aesthetics or otherwise use of the property. And then additionally for temporary services to new construction sites where the eventual permanent customer is not there yet and they need temporary services to construct the building or the house or whatever they're building there.
Excellent. That's helpful. Thank you. Additional questions? Motions?
Mr. Chairman, in EL 26-017, I move that the commission approve the tariff revisions with an effective date of August 1st, 2026.
Discussion on the motion.
Thank you for formalizing this. I appreciate it.
Additional discussion? Hearing none. All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. That brings us to EL 26-018 in the matter of the joint request for approval of a consent and agreement between Northwestern Public Service Corporation, doing business as Northwestern Energy, and Central Electric Cooperative regarding electric service rights. And the question, shall the commission approve the consent and agreement between Northwestern Public Service Corporation, doing business as Northwestern Energy, and Central Electric Cooperative, Inc.? And we'll go to Northwestern.
Good morning. This is Jeff Decker with Northwestern Energy. Jamie Hayek is also on the phone with me. The agreement before you this morning is the result of hours of discussions between Central Electric and Northwestern. With this agreement, both companies have certainty in their service to these customers. We would like to thank Central Electric for their diligence and professionalism in working through these matters. We have a great working relationship with Central Electric and a communication channel for future interactions between the two companies. These discussions have created an awareness of each other's territory. We ask for your approval of the agreement.
Thank you. And let me just check. Ryan Mueller, are you with us from Central?
I'm here. Can you hear me?
Yes, I can for your very first time with us. Go ahead.
Yes, this is Ryan with Central Electric Cooperative. I'd also like to thank Northwestern for their cooperation on this. And we approve everything, and it all looked good, and it was pretty straightforward.
Thank you. Staff.
Thank you. This is Darren Carney for staff. First, I appreciate the electric utilities working together to come to an agreement to continue serving these customers with their existing provider in each other's service territories. These customers service was provided to these customers after 1976, so they weren't grandfathered in by statute, and the commission needs to approve a formal agreement between the utilities in order to meet comply with the statute to serve those customers. And I think how the utilities handled this nicely memorializes the agreement that they have between the parties and the ability to serve the customers in each other's service territory. And so staff would recommend approval.
Thank you. Questions? I have maybe just one. Whenever we do something like this, I'm always concerned about the customers and if the customers are okay with this. So let me just ask both Northwestern and Central, did you have any customers that raised a question about the current arrangement or have any opposition to the current arrangement?
And this is Jeff Decker with Northwestern, and we did not receive any communication from the customers regarding this filing.
This is Ryan with Central. No, we did not have any communications.
Okay, thank you. Additional questions?
So I do have to ask a question of Darren Carney because I don't think he'll be in this hot box very often anymore. So these customers had the provider they currently have really since 1976. So it was just an item that was missed when these two different electric providers worked on the territory maps that we worked on a few years back.
Yeah, correct. Instead of carving these customers out when we did the GIS mapping, for whatever reason, the utilities either decided not to carve them out at that time or they didn't realize they were their service was in the other utilities' service territory. And so after those agreements were set, I think they started looking more in depth at their services and realized that they needed to memorialize these services and clean up the record. So both parties are clear as to what the intent is going forward for providing service to those locations while still retaining their right to serve that location, or depending upon the future growth in the area or what happens with those properties in the future. Hopefully that answers your question.
I'm going to ask maybe just a follow-up to that. So Darren, what we do here today isn't going to be reflected on those maps at all, correct?
Correct. It would be handled like an existing electric service territory agreement, service rights exception, I should say. So the property or the service territory boundaries aren't changing, and you would have to go back to this docket to in the future to see who's serving that location, and if there's a change in the use of the property, then the utilities would have to go back to this docket and review what was agreed upon and how to handle that in the future.
Yeah, here we go. Okay, thank you. Additional questions? Motions?
Mr. Chairman, in EL 26-018, I move that the commission approve the consent and agreement between Northwestern Public Service Corporation and Northwestern Energy and Central Electric Cooperative.
Discussion on the motion.
Well, like you said, and like we say all the time when folks are able to get together on these, we appreciate them working together and making life better for the consumers.
Additional discussion. Hearing none. All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. And that brings us to EL 25-032 in the matter of the petition of Sweetman Construction doing business as Knife River to have Xcel Energy assigned as its electric provider in the service area of Sioux Valley Electric. And the question is, shall the commission grant Sweetman Construction Company doing business as Knife River's petition to have Xcel Energy assigned as its electric service provider in the service area of Sioux Valley Electric, or how shall the commission proceed? And so pursuant to our order for today, here's what we're going to do. All the parties are going to get 5 minutes to make their case. We'll begin with Knife River. We'll go to Xcel, then Sioux Valley, then East River, then Basin, then staff, and then we'll come back around to Knife River for 3 minutes of closing. Or I should say up to, on any of those times. With that, Mr. Van Camp, welcome.
Thank you, Mr. Chairman. I'll endeavor not to use all my time. Mr. Chairman, members of the commission, Bill Van Camp, I'm an attorney for Knife River here today, the petitioner in this matter. With me today is Clark Meyer, who was at the hearing and is the general manager for Sioux Valley, or for Knife River. There's a Freudian slip for you, out of Sioux Falls. I do want to take a moment to thank the commission, staff, and all the interveners in this docket for allowing this docket to move forward with some rapidity based on some concerns and needs that the customer has in getting their project moving forward. And so there was no unnecessary delay in this, and we have moved forward. We had, I think, a fine hearing where every party got their ability to speak their mind and to present their evidence to this commission, and now it's all before you for a decision. I'm not going to repeat or regurgitate what's in my filings and briefings. I just want to point out a few things for the commission to consider before it issues its rulings. There has been the assertion that what Knife River is attempting to do here is ask this commission as an administrative agency to change the language of statute. But I think it's important to point out, and I think it only fell into a footnote of staff's brief, and then I pointed it out in my reply, that there is no precedential finding or ruling as to what is a new customer in this statute or under this statute, or is there a determination of what is a new location? So you're really getting the first bite of the apple here. Congratulations. And so is my client, who's got a large financial consideration that led them to undertake this ask of the commission under the large load exception to seek to have Xcel Energy serve its new facility. Now, customer is defined, no argument. Person is defined, no argument, under 34A-1. But new customer is not defined under 34A-56, nor is new location. Now, there's case law that's pointed out in the briefs, and I'm not going to regurgitate it as to what is a location. This commission determined in the West River Electric case in 2004 what they thought at that time was a new location, but the Circuit Court and the Supreme Court didn't agree. And the court ultimately determined that, the Supreme Court, that location is where the customer is served. Well, I think if you look at the argument that East River made at the hearing, and I didn't point this out, but I do now, that the entirety of this 1,400-acre tract, which is over 2 sections of real property, which we all know how much land that is, it gets lost, but 1,400 acres is a big chunk of ground. Their effort is to conclude that that is all the location of the customer. But there's no dispute that where this facility is going to get built, there is no service. Nobody can serve that. They try to walk the line that they are serving the customer at the location of where this new facility is going to be constructed. But the record's clear that that's not true. Now, if this commission takes the position that the 1,400 acres is the Knife River location and that it cannot be functionally a new location because of the fact that it is one contiguous block of property, well, then my client has to lose this case, right? If that is the determination of this commission. But I would argue to you that the fact that that is bare ground, that it is until they started doing prep work to build this facility unserved, there's no utility services on it, that then becomes a new location, and that perfectly comports with the West River ruling, which the distinction is, of course, the nature of the West River argument and claim in that it was a carved out utility exception when the territorial laws were put into place. But I digress, that's in the briefing. Also, it needs to be pointed out that there's a distinction between the definitions and choice of language in 34A-42, which creates the territory exceptions and the territory rights. 34A-42 describes it as a future customer, that the incumbent has a right to a future customer. I have 1 minute left. Okay. I prefer the bells and the lights. This is not a future customer. This is a new customer. Nobody's defined that. We ask you to define it. All the Supreme Court cases on this subject are not directly relevant to the issue of whether or not this facility, which is new, in a new location, would be a new customer. We ask you to consider the findings in Safeguard Metals, and while not precedential as an administrative decision before this commission and determined by this commission, we think that this project meets with enough of those standards and considerations and warrants are being granted the right to be served by Xcel. Thank you.
Thank you. We'll go to Xcel and Mr. Simpson. Oh.
Thank you, Zev Simpson.
Yep, go ahead.
Thank you, Zev Simpson, Dorsey and Whitney for Xcel. I think Mr. Van Camp put it together quite nicely, what the decision is before the commission. From Xcel's point of view, we have an entity, Knife River, that approached us to determine if we could serve them. It turns out that we can. I think if we can get beyond the question of, is this a new customer at a new location, the factors for the commission to consider really do point to Xcel being the appropriate service provider. I think Mr. Van Camp also noted that this really is an issue of first impression. From Xcel's perspective, we can certainly see it both ways. We think the literal definition of new customer as defined by staff in their briefing does have some merit. We could also see it as looking towards the purpose of the statute, where the statute really is intended to provide service with certain optionality based on the services that can be provided to them. Clearly, Knife River prefers Xcel, and there is an argument to be made that this is a new location, and since it's bare, this is a new customer at that new location. The only other thing I would note is the commission's precedent is very clear that if Knife River had created, Rock Crushing Plant LLC as a subsidiary, they clearly would be considered a new customer, and that the record here does reflect the fact that for all intents and purposes, other than the corporate niceties of a new subsidiary, Knife River does intend to operate this new facility completely and wholly economically separate from not only the existing facility, but essentially as its own separate business. And so Xcel believes that as an issue of first impression, the commission is unfortunately in a position to have to make a determination. We're happy to live with whatever the outcome is. There are pros and cons to both sides, but we believe the commission does have enough authority to make a determination either way, and we're available for questions should you have any.
Thank you, sir. We'll go to Sioux Valley. Welcome.
Thank you, Commissioners. Mike Nadolski on behalf of Sioux Valley Energy. What do you do in a situation like this when there isn't clear precedent and you're wondering whether there's any sort of ambiguities in the statute? I'd submit that you cling to and use and give effect, the plain meaning and effect, to the words used in the statute. Assume that the legislature said what it meant and means what it says. And here, it's clear that when you apply the plain meaning and effect of the words and phrases used, Knife River is not a new customer, this is not a new location, and there's no contract in place as it exists. I'm going to hit some highlights. Sweetman Construction, doing business as Knife River, is a current customer of Sioux Valley Energy. It's been a customer since 2002. When this proposed plant starts into operation, the owner-operator is going to be Sweetman Construction, doing business as Knife River. The location, I'd urge you to look at the exhibits that have been put forth before you. There's BLS 4, CM4, and CM5. And if you look at that, you have to ignore what your eyes are telling you to not see that that's part of one quarry footprint. They're going to use the same road, the same water diversion point. The only thing that separates the two plants is a road that once was public right-of-way, now vacated. The last thing I'll say is there is no will require in the text of the statute when it talks about a contracted minimum demand. That word grammatically functions as a past participle. That's what I have to say, and on behalf of Sioux Valley Energy, I thank you.
Thank you. We'll go to East River. Mr. Brown.
Thank you, Commissioners. Danny Brown on behalf of East River. I don't want to be redundant. I want to stay high level. Our position is fully set out in our brief, which the Commissioners have read and reviewed. I do want to thank everybody who's been involved in this process. I think we've gotten to a point where the Commission now has before them what they need to make a decision. I do want to point out that the South Dakota Supreme Court has said when you're looking at statutory interpretation, you're supposed to read the text and apply it. And like Mr. Nadolski argued, we don't believe that Knife River is a new customer or at a new location. And as the record reflects, there is no contracted minimum demand. We think it's important that Commission hold Knife River to the terms of the statute, and we remind the Commission of the obvious here that Knife River is the petitioner. They have the burden of proof. Is it more likely or not that they satisfied these statutory requirements? And if they haven't satisfied these requirements, then you need to deny the petition. And finally, precedent matters. If an existing customer can create provider choice simply by adding new equipment, new processing line, or a new center on the same property, then the exception starts to swallow the rule. Assigned service areas would become much less stable every time an existing industrial customer expands. That's not what the legislature wrote, and it's not consistent with territory integrity. We ask that you deny their petition and their request, and we're available for any questions. Thank you.
Thank you. We'll go to Basin Electric and Ms. Moore.
Thank you, Mr. Chair, and thank you to the commissioners and the staff and all of the parties for their efforts and camaraderie in this particular matter. I echo the comments made by both Mr. Nadolski as well as Mr. Brown, and I would add this. SDCL 49-34A-56 is an exception to the general rule that an assigned electric utility serves the customers in its assigned service territory. And even before one applies the specific enumerated points in that statute to the facts at hand, there are two prerequisite questions that must be answered, and that is whether there is a new customer in a new location. In this particular matter, the petitioner bears the burden of establishing those prerequisites before it can gain the benefit of the exception in that statute. And we don't believe, based on the evidence that has been introduced, that they are able to do that in these particular circumstances. And we believe that the integrity of this particular act, and that is a deliberate play on words there since it is the South Dakota Territorial Integrity Act at issue, is best served by denying the petition in this particular interest. Thank you.
Thank you. Staff.
Thank you, Mr. Chair. Jenny first for staff. Staff believes that the issue here is whether Knife River is a new customer. On all other requirements in the large load statute, I think the scale weighs in favor of Knife River, especially that the customers will not be on the hook for the cost of this build out if Xcel is allowed to serve And if Sioux Valley does prevail, there is a possibility that their customers will be on the hook for some of the costs of this build-out that will provide no benefit to them. Staff does believe that the ordinary and plain meaning of the statute is a restrictive interpretation of this statute and makes this statute almost unusable. Staff believes that a more modern and reasonable interpretation of the statute would tie new customer at a new location together. In that aspect, if a new location is not served, a customer coming into the new location would be a new customer at that new location. I would defer to the commission on which interpretation of the large load statute they would deem appropriate. Thank you.
Thank you. Rebuttal.
Thank you, Mr. Chairman and members of the commission, and again, thanks to all the parties who've participated in this. I would just ask in closing that we're not asking to change the definition of a customer. We're asking this commission to examine what is a new customer based on the facts before it in this docket and what is occurring on a piece of bare ground with no utility service to it. We think that the Safeguard Metal case, which allowed a new customer in a new location to be located immediately adjacent, a new foundry attached to a building, provides this commission with enough precedential consideration, even though it's not binding under stare decisis, but enough consideration to find that Knife River meets that threshold as a new customer in a new location and should be granted service. Thank you.
Thank you. Appreciate everyone abiding by the time limits, and with that, we'll go to commission questions. Are there any questions? Go ahead, Commissioner Hanson.
Guess I won't. I'll try and stay within my time limit with, there's a lot to say on this. However, I'll try to stick to questions. Just out of curiosity, Mr. Van Camp, and you folks might want to get comfortable in the front chairs. I suspect you will be asked questions by each of the commissioners different times. We'll play musical chairs a little bit. Mr. Van Camp, you present some really, really good arguments. Just out of curiosity, when was, it's my understanding that the alleged new location was not replatted. There's not a separate plat for it. Is that correct?
Mr. Chairman, yes, Commissioner, that is true. Bill Van Camp again for Knife River. It's in the record, I believe, at the hearing that the maps that were created as exhibits were done so by Clark Meyer.
Okay. That was my understanding, but I thought, well, maybe you went ahead and changed it. Is there any take or pay? Maybe Excel is going to have to answer this question, but in staff's arguments, they're saying that the consumer could get hooked with paying for improvements, additional we'll wait for Steve to, excuse me, Mr. Colbeck to.
I can handle that, Commissioner.
Mr. Colbeck just stepped in. Let the record show that. And who's speaking, please?
This is Zev Simser for Xcel Energy.
Okay. And you can tell us whether or not there's a take or pay?
Well, this would be a required minimum 3-year contract for the load to essentially cover, or what we call cost justify, the capital investment for this customer. Those requirements are provided for under Xcel's tariff. And that's one of the big reasons why we believe Knife River prefers service. As you may recall from the hearing, the initial proposals by the cooperative were to force the cost of any capital improvements to serve Knife River onto Knife River as a contribution to native construction. And only later did the co-op try to develop a rate structure that wouldn't impose those costs on them. And so we have a commission-approved rate under tariff that would give Knife River the ability to build out without a significant capital investment, whereas with respect to service by the co-ops, that capital investment will be their choice. Now, they have made that offer to Knife River to absorb that capital investment through the rate structure, but it's unclear to me if the commission were to go ahead and find that Xcel could not serve Knife River, if the co-ops will continue to hold that position, or if they'll just return back to the requirement of a kayak.
So after 3 years, there would be a potential still, I mean, it's not going to be paid off in 3 years, the new facilities.
No, but the revenue will have justified the construction of the facilities in those 3 years. And so while the facilities will still be in rate base, it would be essentially neutral to customers.
Potentially.
Correct. The math would allow it to be neutral to customers because the company has essentially collected sufficient revenue to offset those capital costs.
During those 3 years, as you said.
Exactly, and that's how sort of the math works to what we call cost justify that kind of construction.
Okay, thank you. I'm going to give an example, and I may ask different folks to answer this. Assuming I own a very large apartment facility, 500 some, and there are other services that are provided besides the apartments, using 3 megawatts on peak, and decide this is an old facility, I want to tear it down, rebuild it. Right next to it, there's enough open land, there's a house on it to be torn down. Going to build a much, much larger facility there. And that's going to definitely use over 3 megawatts. That is a new facility owned by the same persons. The old one going to tear down eventually and build all brand new. And assuming that the old one, when it's torn down, is going to retain the same provider. But the new one, it's a brand new piece of property. Nothing's on it. It will have a new address. However, that's that particular argument I don't go with because railroad crossings are so difficult in this particular incident. So my question would be, why wouldn't that brand new facility be allowed to be under a different provider, and what makes that different from this one? I'll ask that of Mr. Nadolski.
Thank you. So I think your question, Commissioner Hanson, begs the question of if the PUC thinks that the current statute does not reflect the language or the guidance necessary to address what is happening in the state of South Dakota today, then that project is really one for the legislature and not one for the commission. Commissioner Hanson, your example while their similarities are quite different from this, and that's why I alluded to the exhibits that are on file here. And it depends on what factors you have at play. In this particular case, if you look at what is going on with Knife River now, it's really hard to argue that that's not part of one quarry footprint, which is different than the example that you gave. And so I would say there are material differences between that example and between that and what's before you here today. And I would also submit that if you give the plain meaning and effect to the words and phrases, that would not qualify for the large load exception. And again, I understand and empathize with what the commission has to grapple with here. The statute perhaps needs revision, but I would submit again that that's not a project for the Public Utilities Commission. It's the responsibility of the legislators in the state of South Dakota to refine and clarify what it means for an entity to qualify for that large load exception. So that would be my answer.
Well, there is no doubt that there's room here for the legislature, and I will suspect that I won't be here in January, and I am certain that, at least in my own mind, that my fellow commissioners will be encouraging the legislature to take a look at this, because this is something that has had some challenges all the way back to the 70s. And while that's true, it is not, the legislature is not in session, and so we need to make that decision. You talk about some ancillary issues surrounding this. I won't get into those because I'm dismissing most of those, and that's why I put out the example that I did, because it really boils down to the example that I gave you. So I appreciate your answer. I have some other questions, but my 5 minutes are up, and I'll let someone else take a shot.
I don't think either of us have questions, so go keep rolling.
Oh, really? Within my notes, most of it is for me to chat. I don't imagine that Mr. Van Camp has any suggestion as to why that would not be an exception. I think you'd probably agree that it's a new location. Am I guessing correctly?
Sorry, Mr. Chairman, Commissioner Bill Van Camp again. I would think that this commission is in a position, as it did in 1977, to determine what is in this instance under the facts before it a new customer. If the legislature or the courts decide to tell you what a new customer is, they can do that. But as of yet, they have not, and so the issue is to be determined under the facts in the docket before you.
Why on earth would there not be a take or pay for this? Shouldn't we be concerned about the consumers?
I'll leave that question, Mr. Commissioner, to Mr. Simpson.
Commissioner Hanson, I think we are quite concerned about the consumers, and I think that from a policy, not statutory interpretation question, it's an important one. Fundamentally, our requirement under tariff and state law is to present to the customer its best option. And the cooperatives do not have such an obligation, which I think is part of the imbalance on a service perspective between how Xcel would serve the customer and how the cooperatives would serve the customer. Additionally, from Xcel's point of view, we have an approved tariff that allows us to manage it in the way we are proposing, which has been thoroughly vetted, has been through rate cases, will provide additional revenues to our customers. And so we believe that our proposed structure through an approved tariff does actually take into account both the customers, existing customers, and this new customer at a new location in a way that's probably the best outcome for everyone, because it is a mandatory period that will provide enough revenue to justify the capital improvement. Whereas if you look at the cooperative's initial outcome, their view is no customer should be covering the cost of these additional capital improvements, and therefore Knife River must. And so so their balance is very much in favor of their existing customers, which is how the cooperatives are managed. But it does put this new customer at a significant disadvantage. And so that's a policy question that needs to be weighed. With all of that said, I think the record in this proceeding is very clear. If we can meet the threshold that this is a new customer in a new location, all of the factors that the commission is supposed to consider do weigh in Xcel's favor. I think that that is abundantly clear within the record. With respect to your example, I think that's part of the challenges of the statute here. And I believe that that would be an issue of first impression. I think the record makes, it at least supports a view that this is a new location, that this isn't an expansion of an existing plant, which in other states statutorily would have been included if that was permitted. So, for example, if you have an existing soybean crushing facility and you're adding another 3 crushers to the facility, that's clearly not subsumed within this exception. But here, I think you have a new facility doing different work that just happens to be adjacent. And there's nothing there. At least that's one interpretation of the record. And if there's nothing there, the commission could determine that any customer that comes into a new location where there's nothing there has to be a new customer. A new customer at a new location, and then there is the threshold piece. But just from a ratepayer protection perspective, you know, the IOU is regulated by the commission. The commission oversees our rates and oversees the structures and the offers that we have available to our customers. We cannot deviate from those. Whereas with the cooperative, they have a lot more flexibility, but it also means that there's not as much oversight going into the future.
Ms. First, do you have someone who, on the staff side, who could enlighten this from why the staff believes that it would be important that there's a potential for effect on the citizenry?
Thank you, Mr. Chair. Jenny First for staff. I think it would go into the economic factors and other pertinent factors, I believe they said. And the record is clear that they said that these customers would not be on the hook for any of this cost, as opposed to the co-ops that could, their customers who we don't protect at the PUC could be on the hook for those costs. But as far as the customers under the umbrella of the PUC, they will not be on the hook for any of the costs for that build out, which is why I think that that's important.
Thank you. Thank you, Mr. Chair. I believe that's all the questions I have.
Any further questions? If not, motions. Commissioner Fegan.
Mr. Chairman, in EL 25-032, I move to deny Sweetman Construction Companies doing business as Knife Rivers petition to have Xcel Energy assigned as its electric provider in the service area of Sioux Valley Electric.
Discussion on the motion.
So Knife River, you bear the burden of proof. And when I look at the threshold, I don't see that you have met it. When you look at all 6 factors that we have to look at and make sure it's satisfied, I don't believe Knife River has satisfied new customer and new location. This is a very important decision. Large load is impacting the electric grid, infrastructure, generation, all of that. And we have rapid growth, and certainty of the law governing large load is essential for infrastructure build out and grid operators also. So it's a very, very important decision today. We must interpret the statute according to plain language. And we must be consistent with the South Dakota Supreme Court. Until the legislature gives us a more clear definition and it is more defined of new customer and new location, we don't have the ability or the authority, statutory authority, to rewrite statute or law. We have to look at the plain language, and we have to make sure long-term planning of infrastructure and generation and et cetera, while we're in a very fast-paced growth, has certainty. So until the legislature changes something, those reasons I move to deny.
Additional discussion. I am going to support the motion to deny, and let me explain why. Obviously, South Dakota has very strong territory laws, and I suspect that both utilities here today support strong territory laws. It's one of the reasons that we have efficiently functioning utilities in the state. 4934A56 offers what I consider a narrow exception to those territory laws. Now, the legislature could have said, large load, you choose. They didn't. They provided a narrower exception than that. And at the top of that statute, they provided some hurdles that have to be cleared. And then they gave us some specific areas that the PUC was to evaluate. And as Mr. Van Camp said very well this morning, there have been a lot of litigation on this and absolutely nothing that really is helpful to us in making our decision today, which kind of surprised me. I mean, given all the litigation, that this question hasn't really been answered before, and so we get to do that. So let's look first at this idea of a new customer at a new location. I'm intrigued by the idea that the legislature used the word new twice, right at the top of this. And what that tells me is that they truly meant this to apply to something new, not something cutesy, can we fit it in, but it's got to be something new. The emphasis was on that word, or those 2 words. As far as being a new customer, it's clear Knife River is not a new customer. They're an existing customer of Sioux Valley and have been for a long time. New location. This is not a new location. As was clearly shown on one of the map exhibits, there is going to be a conveyor going from one area of the crushing plant to another area of the crushing plant that goes across the existing sand washing plant. It ties it all together. And so to say that part of this is a new location when it's ultimately all tied together, it's certainly by that conveyor, if not by other things, I think it gets pretty hard to argue that it's a new location. We've got these parcels are sandwiched together. And then the fact that, Knife River, told Minnehaha County, this is an expansion. And while I understand your argument that that was for a different purpose, I get really troubled when you're telling one government one thing and a different government a different thing. I don't get that. I don't buy that. And so if it's an expansion, then it's an expansion for all purposes. And so Knife River fails these initial hurdles. But I'm going to go through the other 6 just to weigh in on those. Since we listen to the input, I get to give my output. Certainly, it's outside the municipality. On this issue of the contracted minimum demand of 2,000 kilowatts, I view this as prospective. Okay, I'm going to come down on Knife River's side on that. That to expect them to have a contract in place up front, I think, is not reasonable. I think that's not logical. I don't think the statute would ask for an illogical conclusion there. Having said that, if we grant this, and when that contract is ultimately cut, it's for something less than 2,000, well, then what we've done is null and void. But I think they certainly have the opportunity to cut that contract in the future to comply and therefore clear that hurdle. 6 factors. The first and second factor, I think both providers equally can meet that. The third factor, system upgrade and economic factors both seem to hold other customers harmless. There's been some discussion about that this morning. I have confidence that either provider is going to figure out a way to do that. Proximity of facilities. This one also weighed in Sioux Valley's favor. They've offered 2 different viable options that are coming from relatively close locations. Xcel, on the other hand, and I made a little bit of a deal of this during the hearing. They kept talking about we've got to come 10 miles, but the map they submitted only showed about 2 miles. And I asked, well, where's the rest of the map? And we got the rest of the map, and it's showing this kind of circuitous route, and parts of it are improvements, parts of it are new, and so Xcel certainly is going to have to do a whole lot more work to provide this than what Sioux Valley will. And so I think that tips in Sioux Valley's favor. The preference from the customer, obviously, is for Xcel to serve. No question about that. I don't know that it's pertinent, but it's certainly not clear anywhere in the record as to why Xcel was the preferred customer. You don't have to tell us. Doesn't really matter for our decision, but it's clear that that was the customer preference. And so far as being able to provide adequate service, I think both utilities could certainly do that. But going back to the top of the list, the initial hurdles, I don't believe that Knife River can clear those initial hurdles, and hence I'm going to support the motion. Additional discussion. Commissioner Hanson.
Mr. Chairman, thank you. It is clear that there needs to be some clarity, and I'll look forward to reading about it in the legislature as it goes through the process. I'm not going to come back up here and testify on it. I think you folks will take care of that. I went to bed last night rereading a lot of these things because I was so in between and wrestling with where it should end up. And I woke up before I opened my eyes. I laid there turned my alarm off and laid there and argued in my mind. Actually, I woke up prior to that. It was the alarm that got me out of bed. But I argued left and right, took different positions as to why, and interestingly enough, which never happens, I was opposite of what your positions were. I thought it was a new location, but not a new customer. You thought it was the opposite. I think that's part of the big challenge here. But then I resorted to, I went through the same things that you folks have very well articulated. I won't go through all my notes. Thank you. But it did boil down to how will this, we can't determine, as has been correctly discussed, and I hope this commission never does regulate co-ops. However, this is, I guess, our one chance out of thousands of not having a chance. of influencing the potential cost to cooperatives. I understand, and I believe that everyone is stating what they truly believe. But I can't help but think that some folks 3 years from now could end up, or sooner, end up in a situation where they have to pay a lot more for electricity without that take or pay situation. And that's what it boils down to. The proposal on its merits are interesting, they're exciting. I'm not going to step into shoes and pretend that I am operating the facility and should know the ins and outs of whether it's a good decision or not to go with Xcel, but I'm going to agree with my fellow members, just strictly on a basis of how I feel it has a potential to affect consumers in the future. And more importantly, the purpose of the statute. The purpose of the statute, which has been discussed a number of times, is to protect the consumer, to make certain that the consumer is not adversely affected by this. Certainly there's a, as has been pointed out, there's an exception, a valid exception to the rule, but the whole purpose of the rule is to protect the consumer. And it's gone both ways in Supreme Court decisions. And so from our standpoint, I guess we might look forward to the litigation on this one as well. However, I truly believe that the purpose of the legislature was to protect the consumer, and although it wasn't clear completely in how they articulated it, the fact is there is a potential for adversely affecting the consumer if I did not support the motion. Thank you, Mr. Chair.
Thank you. I appreciate those comments. I'm just going to add, obviously the legislature was concerned about consumer, but I think the legislature was also, they created the Territory Act, and I think the legislature was also concerned about maintaining the integrity of territory lines and the ability of utilities to count on those lines as they go about doing their business and plan their expansions and those kind of things. And that's why I, talked about this, in my mind anyway, being a pretty narrow exception. Additional discussion. Hearing none, all those in favor of the motion to deny will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. Motion carries. And maybe we'll see you down the road, Mr. Van Camp. Understand. Don't see anybody signed up for public comment. Announcements. Next regular commission meeting will be Tuesday, July 28th, 9:30 a.m. right here in room 413 of the State Capitol building. Anything else for the good of the order? Is there a motion?
Move to adjourn.
Those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. We are adjourned.
SDPB helps shape South Dakota's future by educating, informing, and inspiring the next generation of thinkers, leaders, and creators. SDPB. Good, useful, and full of wonder.